Yeah.
Hello, everyone. We are here joined by just the indomitable. I I don't have other words to describe how prolific. Just you are everywhere. You've been everywhere on every panel, Veronica. We're here to just welcome you and celebrate you today, joining us live. And I have no idea what that sound is. Joining us is Veronica. What was
Yeah,
that?
thank you very much for the invitation. I'm not sure if you can hear me well, and
Yes, we can.
yeah, there are I guess hundreds and thousands of panels, so I guess there are much more visible and much more educated fans of legal issues surrounding AI than me, but I'm very happy to be here and looking forward to our discussion.
Yeah, thank you so much for joining us. I mean, for me personally, this topic is fascinating because music is my passion and, I play the instrument and perform sometimes. So, I'm really looking forward to this discussion. I just want to tell our audiences there will be more questions than answers because this area of law is completely uncharted territory. Like it's even less charted than the other issues around surrounding generative AI that we've seen, lawsuits popping up over the last year. However, the AI issues regarding music are very, very, very novel. So we don't really have any answers. We have some, court decisions, some, U.S. Copyright Office decisions surrounding not the AI generated music, but some other AI generated content that we think might be applicable. But again, we're going to be theorizing and discussing those issues, and hopefully, you guys will enjoy the conversation. And please do comment, ask questions, and I will let Veronica introduce herself because she has a very interesting background. She's joining us from Europe, so please, Veronica, tell us a little bit about yourself and what you have been, what your practice been, and your research was about.
Okay, great. So first of all, thank you for inviting me, and many thanks to everyone who decided to spend a few uh, um, challenging moments with us. Because, as Elisa said, we won't have the precise answers some of the people might be looking for. But I think this will be very interesting because we will be comparing American and European point of view and a recent legislation as well. And that's perhaps why I'm the right person to sit here with you now, because my legal background is a very nice marriage between the American experience and the European one. I got to the AI through big data and through my time spent at UC Berkeley, at School of Law, and later on at Berkeley School of Information. And that gave me opportunity to learn from people who were dealing with legal and ethical issues and big tech and all the research topics that later on became the big boom of mainly generative AI as we know it now. And for a couple of years now, I have been focusing on research specifically dealing with legal and ethical issues related to intellectual property. This means also personality rights, personal data protection, right of publicity, or personality rights as we tend to call it here, and obviously copyright, and sometimes sadly forgotten issues related to trademarks, because we have a couple of those when it comes to generative AI as well. So music and generative AI. When you told me about this topic, I thought you could barely have chosen a more complex one. So congratulations, you made it. This is complete madness.
Yeah, I just wanted to, to just kind of let our audiences know that this is, as Veronica mentioned, these are kind of the main topics we'll be discussing today. about some commercial aspects of AI in music industry, because we already have a lawsuit in the United States. Some of the legal issues that are kind of more seem to be a little more straightforward to us as legal professionals, but there are others that are maybe not less straightforward when you're thinking about AI in music. And also, since Veronica has this EU exposure as well, we'll be talking a little bit about United States versus EU approach, because I think that the approach is a little different, where in the European Union there is an emphasis on like moral rights, like of the authors, whereas in the US it's more of a kind of commercial focus. And also we'll try to talk about creators who are using AI tools during their creative process, and what kind of challenges they're facing, and what could be kind of the future solutions maybe for them. But again, so this is kind of our main topics, but we might digress a little bit as usual, so please bear with us. Yeah.
So let's jump right in. Commercial implementation. Guys, I mean, it's been all over the place, right? We've heard it's been all over the news, the fake Drake songs. Everybody is just synthesizing everybody else's content, just songs, and it's been proliferating quite a lot. And the main kind of issue with that is, right, nobody can tell what to do about it when it comes to how do you protect your rights when it comes to your music, your songs, your digital content, for that matter. And what do we do about it? No pressure today.
Listen, just when I'm reading the headline, two immediate thoughts came to me, how it is perhaps interesting that we mostly read about the lawsuits and controversies when it comes to use of AI generated music. But what's happening, and is perhaps much more important, is that the AI generated content is widely used, and it has been so for some time now. And I know that some companies are trying to take baby steps, or maybe step on a break, as you perhaps have heard that some big corporations have this or require this clauses in the contracts with creative agencies that no AI will be used to generate part of the campaign, because they are worried about legal and ethical consequences. But then there are other companies who are using generated content, and it obviously has some consequences on the market, but it might lead to this sort of second wave of lawsuits. And this leads me to the second thought, because this is my personal opinion, but I would expect some lawsuits coming up later on in the upcoming months and years due to the AI Act, because there is a transparency clause, and it requires, simply speaking, the disclosure of training data, although quite generally, and we are still in a process of learning what the disclosure should look like. But imagine that the content used perhaps also in other countries than Europe will include works created by European artists. So that's quite interesting, I guess. And also, if you are an artist willing to protect your content, I think this is, I don't know, like standing on a raft, because the landscape is constantly changing. You see companies trying to opt in for fair trained data sets, for fair training, and licensed data sets, or synthetic media, synthetic training data. This is also a huge development. So I think we constantly need to look up for the new trends.
Yeah, I think this is a good segue, because you were talking about, how in the EU, the companies or the artists might need to disclose the use of synthetic data or AI generated content. And I just wanted to remind our listeners, if they for people maybe who didn't know, this was not a lawsuit. It was actually a registration case where a gentleman named Thaler, he had a machine actually called the creativity machine. It's just a computer. So he tried to register a copyright claim for the machine as the author with the United States Copyright Office. And in the United States, I mean, for the human work to be protected by copyright, you do not have to register it with the government. It's not mandatory. However, if you at some point find yourself willing to sue somebody and claim statutory damages, for example, that registration will really come handy. So the United States Copyright Office said we cannot register a copyright authorship for the machine because it lacks human authorship. So the copyright only protects the creations of human mind. And also, I think later in the process, U.S. Copyright Office also clarify that when you apply for the registration, you have a duty to disclose if you're using any AI generated content. So you have to be transparent. But again, I mean, it's a requirement, but it remains to be seen how this is going to be playing out kind of in the practical sense, right? And as opposed to, I know that we also discussed the Lion case a little bit, and folks for listening, these are not like music related kind of scenarios, but we were thinking that maybe some of these concepts could be applicable along the road for the musical creations as well. So Veronica, if you want to comment on the Lion case, because this is interesting. This is the kind of EU scenario, right, that happened in the German court, and I think there was a very prominent discussion around it. And if you could explain us a little bit why this was important.
Oh yeah, sure. So let me start from go in a reverse order to start with Lion. Honestly, I think that there will be perhaps in the future other decisions that will be able to lead us better than this one, because perhaps the craze about the decision, and the discussions were bigger than the influence this will actually end up having, for two reasons. First, most likely the parties will appeal, and also there were some, let's say, weaker parts of the decision that led to some inconclusive discussions. But basically, there were a couple of points that the court was dealing with. First, the position of research companies versus commercial use. And also, this was not directly dealing with training of AI. The party at issue was submitting training data in form of a set consisting of URLs of works, and one of the authors of the works that were led to through the URL sued them for copyright infringement. So for me personally, what was really interesting was the let's say the argumentation of the court about research nature and cooperation with commercial subject, because we could see in the past that some of the research entities ended up being commercial players in the area of generative AI later on. And also, since I'm dealing a lot with the AI Act, this is interesting to see, because there is exception for research. But again, when it comes to the market, again, simply speaking, the exception falls apart for obvious reasons. And then when we are talking about let's say non-commercial use of other systems that can be tweaked by basically any user, and what legal and ethical consequences it may lead to, you can see that it's very hard both for the lawmakers and for the courts to see where the protected let's say domain of research and some socially beneficial use of artificial intelligence should be defined. So And yeah, well, there was one more interesting point, and that was the TDM exception and reservation of rights. I don't know if any of our listeners are familiar with that, but that's the trend that, as I understood, is now seen also in the American law, that you can sort of try to prevent crawlers from training from use of your data for training purposes. Whether it works technologically, whether it works legally, that's a whole different question for a whole different podcast about the way how it should be machine readable and stuff like that. But that was one of the points the decision was also dealing with. So basically, translated into creators' language, it's good idea if you can to use the reservation of rights. That's at least my opinion. It doesn't always save the day, but at least you have the question is how strong cards, but at least you have some cards in your hand. So some people claim it should be let's say included in the metadata of the file. Some people claim that it's sufficient if you have some written reservation of rights on your website. As I said, this is for a much more longer and complex discussion, but these are just a few bullet points that were interesting about the decision, but I think we will have stronger ones.
Yeah, I remember you mentioned that in the EU there is kind of a lower bar for the reservation of rights, and by reservation of rights, just making sure that we understand what that means in the EU context. Kind of what does it mean exactly?
Well, yeah. Let's say the lower bar seem to be set, or I don't even want to say set, as it's not, it's just a German decision of one of the courts, but the court's let's say interpretation of the reservation of rights proclamation is being set. There's quite a low bar set for it in this decision, but basically we have this directive that claims that there is a for let's say data mining. It is use of copyrighted works is allowed for data mining, but there are some exceptions, and you can use your reservation of rights to opt out. And the question is, how do you opt out? And the AI Act works with this term from this copyright directive. And then again, there is exception where you cannot use reservation of rights. But once again, that's for a broader discussion.
Yeah, so I'm just thinking, what does it mean for music creators, for people who are composing, and how are they going to designate their content? Let's say if they are opting out, right? So in terms of images, I think that when we discussed that during our prep call, right, Elena, regarding the Adobe tool that they have just released.
Yeah.
So yeah, it would be interesting. The question is whether there will be something like that for music as well, because Elena, do you remember what Adobe has just done for
Yeah.
the content?
They
Authentication.
they were advertising this content provenance initiative, content authentication platform. So they just rolled it out. It's available to everyone online. Anyone who is generating content, digital content, creating content online, they can just use the platform in order to create this chain of ownership, or whatever was done with the image, where the image was taken, any manipulation that's been taking place. So it's literally everything is recorded, and you can just see it clearly. So yeah, as we were talking about it in our prep call yesterday, right? Will it come down to something like this implemented for the music industry, right? Is it even possible? Because as of today, it seems that the only kind of, when it comes to copyright protection, I'm not talking about the personality rights and name, image, and likeness rights, but when it comes to copyright, we pretty much depend on transparency, right, and disclosures, because otherwise there's no 100% way of telling and indicating whether that song or this segment of a song, the sample, right, of a song was AI generated. So it's pretty much transparency. It kind of, that's what just is based on. And that's my sick child in the background. So yeah, that's pretty much it when it comes to copyright. But obviously we have other laws in place that still work. But when it comes to just good old copyright laws and music rights, it's very important. The transparency factor is very important, and obviously we don't see it quite there yet. It's not picking up.
If I may jump in,
Yeah.
we might see an interesting development in this area, both technological and legal. Once again, because of the AI Act, there is another transparency clause. This one is not regarding training data. This one is regarding use of technologies allowing to generate synthetic content. So basically transparency when it comes to deepfake, which under the definition also is related to audio. So this might be a good example of how things could be done in the future, because the AI Act should apply also to companies with registered seats in the United States or anywhere else, as long as they are entering the European market, meaning their products, right? So I know that this will be subject of another legal discussion in the upcoming months, but at this moment, that's how we all see it. And since the AI Act passed, we are gonna see how the Brussels effect might play out in other countries, with local laws, etc. But when it comes to developers, in theory, in simple words, it should require them to include some sort of technological measures allowing to include the message that this content was synthetically sort of manipulated or developed with the output. And then again, the provider of the system has similar obligation of the transparency. So when deepfakes should be required to be somehow flagged, and when this information should be part of some sort of watermark in the content, the question is how this will influence, let's say, copyright area. And the technological problems that we will be dealing with will be again vast, because even with the generated content, the best tools don't have 100% reliance ratings. And when you are to prove that the person is in breach with this obligation, I would love to see how this will be proven, really. But the technology is developing fast.
And
Yeah, it is definitely
at least
early stages. Yeah. Yeah, go ahead, Alana.
Yeah, no, I was gonna say that when it comes to watermarking techniques, right? Different companies have rolled out their own techniques, but the problem is they work much better for images, AI generated images, than AI generated synthetic music, right? So what do we do with that, and how do you I don't know, fight that again? It comes down to transparency, at least as of today, right? And by the virtue of just disclosures, because cloning somebody else's voice, it's very easy today. All it takes is 3 seconds, and there you have it. You have this famous singer's voice, and you can generate your synthetic music and then distribute it all over the world, which a lot of companies do. So, how do you fight that? I can clone this voice right now and just that's interesting. And it's what more interesting kind of is digressing again totally, but different countries, obviously different jurisdictions, look at that differently, right? Some countries have name, image, and likeness rights. Other countries don't, right? For example, in the US, we have that, but it's for celebrities, right? If somebody clones my voice and distributes it everywhere, nobody's going to care, and just kind of it just circumvents just us regular folks. So when it comes to that, how do you rely on the existing legislation, because that pretty much is non-existent. So that's again interesting.
Well, I would like to hear from you guys. From my point of view, I guess the strategy is similar to the one you can see with, let's say, copyright issues surrounding AI. For instance, the theory that you cannot claim copyright to merely generated AI content, and how people are trying to legally bypass this lack of ownership, or exclusivity to the content created by use of generative AI by other, let's say, legal measures. So I think it always depends on the use of the name, image, and likeness, and that might allow you to use different strategies. Uh, the protection in the EU, I believe, is stronger than in the United States. We don't have this stronger protection for people using their name, image, and likeness commercially. We have two sets of laws that are protecting name, image, and likeness, not speaking about criminal offenses related to misappropriation of name, image, and likeness. But the fact remains that I'm not entirely sure how this will sustain the fast development of technology. I know there are some tweaks in our legal system already taking into account the misappropriation of name, image, and likeness by generative AI, but I don't believe it's going to be sufficient. And I really love the point that Elena made. We seem to be hearing a lot about visual deepfakes, and not only from copyright perspective, but also from, let's say, criminal law perspective and other much vaster potential issues. I believe that voice cloning is much more maybe not much more dangerous, but it's much less talked about that it should be. And perhaps the regulation should be sought there much more eagerly than it is. This being said, I know there are tens and tens and tens of bills down the pipeline in the United States. The question for you, another one, is what do you think about it? Because isn't it counterproductive? Isn't it just one big mess on somebody's desk? I don't know, you tell me.
I'm gonna briefly address that. So we have obviously a bunch of bills proposed, right? And a lot of them passed, and a lot of them were signed by the California governor last month. Actually, I think about like 18 AI bills. So we are very, very interested in, for kind of this conversation purposes, in the Elvis Act and No Fakes Act, right? So the AI legislation has been very concerned with transparency, deepfakes, name and image and likeness issues, kind of in this category as well, right? The industry is totally behind it for obvious reasons, and those bills have been generally, they've seen pretty much support all over the kind of on both sides of this aisle, so to speak. So the industry, the academics, and just pretty much all the regular people as well. So things are looking up when it comes to this. A lot of legislation is being passed, and I think people, no, I'm not talking about the Congress, but just the states, there's been a patchwork of legislation when it comes to this as well. And that's a different, a totally kind of separate subject to address. But there's been this patchwork of legislation statewide, and every state differs on how they address name, image, and likeness rights. And when it comes to generative AI as well, and the deepfakes. So it's just kind of this intricate system of different pieces of legislation coexisting, and how it's gonna, how it's gonna continue to spread, because obviously Congress will be pretty much MIA for some time going forward. With the election coming up, nobody knows where things will turn. So
Well, if you ended up having federal legal protection, statutory protection for name, image, and likeness and voice, that would be really great, I guess, because after all, it would also save money and hustle on both sides. If you are a legitimate, you know, business person or company, you want transparency. You want clarity. That's natural. When it comes to copyright, my feeling at the moment is that it's being developed more by a case law and initiatives by big tech and companies, and on the other sides, creators associations and SAG-AFTRA and unions of all sorts, rather than by law. Would you agree? Tell me more about it, maybe.
Yeah, Veronica, I think you're totally right, and I wanted to put up this I don't know. Sorry, the slide actually. So you're absolutely right. I mean, it's just the way it works in the United States. I mean, federal jurisdiction and copyright law is a federal jurisdiction. It's pretty limited. Like states have more kind of robust jurisdiction when it comes to all those things that you guys discussed. However, and yes, in the U.S., it's all like federal legislation is going to be way behind. We are already dealing with that in courts, and specifically federal courts, because this is copyright domain, right? So we do have a lawsuit at the moment that was just filed this year, and that has to do directly with this particular issue. Is that Universal Music Group, Sony Music, Warner, they sued Suno AI and Udio AI. This is just one of the online music AI generators, claiming that they infringe their copyright for a bunch of music creations, and in the United States, I mean, recently this fair use doctrine has been discussed a lot, because that's how it's been litigated in the courts, because that's kind of seems to be the ultimate defense that the defendants are kind of turning to when trying to answer those complaints. It's I mean, there are a few factors in fair use, but I think that recently, and correct me if I'm wrong, Elena, if I remember correctly from the recent Supreme Court case, is that one of the factors, and specifically the commercial factor, right, is being that's where the courts are kind of leaning
that was
into
the
when examining those
case.
cases, right? So
Yeah.
and so for now, this is what we have. So the online music generators will be claiming their their use of these recordings is fair use, which means that they could use these recordings for their own purposes. But on the other side, we have music labels and composers and artists who are pretty much claiming that they're being hurt commercially, because, as they're saying, AI robots and music generators are not being paid royalties, but we are. So this is our livelihood, and we kind of depend on that. So we don't really know whether this is going to go. So it is a puzzle for the courts, as I said. And we will see. I mean, it's really early stages. We will see, I guess, which claims are being dismissed by the judges, kind of a pre-trial stage. Because, and also to mention, all of the other Gen AI lawsuits that we have ongoing since last year. I don't think any of them gone to trial yet. So we're still in that preliminary stages. So we don't know. We don't know. But I mean, we can kind of discern maybe a little bit from some of the claims that are being dismissed. Um, you know, um, by the judges at this point, but it's really we really don't know whether this is going to go. And just back to square one, yes, it will be decided in the courts. Yeah, we will see. I just wanted to show folks that um, there are actually so many AI music generators out there. I mean, this is just a snapshot, just a few of them, but you'll be surprised how easy it is to create a music or to clone a voice as well. There are all kinds of services out there. One of them, Speechify, actually myself played with it. It's kind of a little scary how easy it is to clone your own voice, to have it say some like nasty things about your neighbor or something. I mean, this is the benign scenario, right? But in terms of music, yeah, it seems like it's very easy to do that. Which brings me to this slide, which I like. I think this tweet went viral at some point, and I mean, it doesn't mention music here, but I think it just touches on this like overall issue, which I've been thinking a lot about. Why on earth do we need AI music generators? Why? I mean, I'm ready for you guys to play devil's advocate here because I think that I can see, some benefits of using AI music generators for some stuff. But if we are to think that we want to outsource, so to speak, some of the routine and mundane tasks to automation, um, why do we want to outsource something that actually makes us human, makes us creative beings to a machine? Can you answer this question or at least like theorize about it? Because I think this is the crux of this like debate. Um, you know, why would we want to
I
give this away?
I think that kind of comes down to the general purpose aspect of this technology, right? You can use it for pretty much anything. It depends on the user. You can use it to generate and clone someone's voice, a person who lost their voice, for example, and can't use the voice anymore and can communicate with their voice that's already been restored, right? You can in the movies they the latest one was uh the actor who voiced Darth Vader, you know,
Yeah, James
his
Earl Jones.
estate. His estate. They agreed that the movie company could use his voice, continue using his voice in the movies, so the character essentially, you know, just has the same voice and etc. etc. For stuff like that, I think we can pretty much come up with a lot of very useful applications of this technology. Obviously, on the flip side, there is just voice cloning and using it to scam people out of millions of dollars and uh, call people up and try to extort money from them and stuff like that, or just pure and simple good old generating some trash music and stuff. So again, it depends, but it all comes down to the user. And to kind of briefly switch um, to regulation of this technology, it might come down to the regulation of the use of this technology, not technology itself, right? Because how can you regulate something that you have no idea that might be used in the future? So that's my digression.
Yeah, I'm really happy that Elena mentioned this, regulation of the use of technology. This precisely has been the approach of the regulators with the AI Act and the risk-based regulation, which I understood is picking up in other regions as well. What is beyond my imagination is how well, it's more of a silly question because how it's the damage is done, right? What worries me is the complete democratization of systems and tools that are out there, most of them free of charge, many of them with at least questionable developers with questionable background, I mean companies now, with sometimes very unreliable privacy policy, with terms of use that you definitely should read more than once, and with abilities to really very well and very easily assist with criminal activity and unethical acts, and that's everything here on the plate. It's a buffet for everybody to use, and I understand that it's important to have open source technology and to have the ability to open the technology to as many people as possible in order to innovate. But on the other hand, when it's technology of this damaging potential, I think we should have thought twice, at least think if we are capable of having measures, and not perhaps legal measures but technological measures, how to deal with the consequences, with the outcome, and with the content, which is now running through internet, and we have so many generated content. We talked about slop, and that's the least of our problems, the generated content which is mimicking people's voices and people images. It's much more of a concern. And when it comes to livelihood of creators, that's one of the big potential issues for society as well, because I'm worried that not only we may eventually forget what does I don't know, an actual wall painting in ancient Egypt have looked like, because the internet will be flooded with generated semi-realistic depiction of it, but also that people will have even less motivation to think creatively, to work as a creators, to study these subjects. The school might have too little students, and my belief is that creative thinking is important not only for professional creators, or that it's something like something nice to have. It's fundamental for our society, for our way of thinking, and even in business and other areas. So that's where I see Alice's concern. Why would we do this? I'm worried that the answer is because it generates attention, and we are attention-based society at this moment, and it's much more interesting to talk about, I don't know, deepfakes and how robots can write an opera now, rather than saying, look guys, it helped archaeologists to find lost city, or it can help doctors, it can help scientists. It generates less clicks than deepfakes, I guess.
Yeah, I think, I mean, commercially speaking, why this companies who are building their business around AI music generation, why they would want to do that, because I think that even these guys that are being sued right now, right? I'm gonna go back to this slide, right? So they actually, I think both Suda and Udio, I think they have like a free and kind of subscription kind of model where you can do that for free, or you can pay like a monthly fee and then generate music to your liking. So there is definitely, I guess there is money in it. So, and so maybe people feel inspired somehow when they put a prompt and saying like, hey, compose like a song for my dog, in the style of like heavy scream metal or something like that. So
Yeah.
yeah, the question is, yeah, and there is also, I think we discussed a little bit from like a legal perspective, whether the issues are, I mean, kind of on the digestion part, right, on the kind of a training, your model on this data and also on the output. And I think we're just kind of, and again, the input, the digestion part is really unclear. So we don't know how that's going to play out, again, in the course in the legal system. But the output, who owns the copyright and whether it's even copyrightable, again, we're just kind of going back to square one. Right. And
Yeah,
whether it's
no,
going to be,
I really, really love this issue about AI assisted works.
Mhm.
It seemed to be, and again, this is oversimplification, but it seemed to be globally cut through case if you have just merely generated, as you said, generate song for my dog, and that's it. But when you have an AI assisted work, and different systems allow for different, let's say, palette of making creative choices to the person working with the AI assistants. So I
Mhm.
think this will be very interesting to watch this development. And when you look what tech companies have been doing lately, I mean, opting in for again, licensing content for training data or using synthetic training data, it
Mhm.
seemed as though, at least to me, they either said, we know there will be, more controversies and more lawsuits, so let's better play it safe for a change. Or they anticipate that unless the copyright will develop, there won't be clear answer for the, let's say, input question. So it's better to just try to go in different direction. Although let's not discuss how the training have looked before and what is already ingested in the models. Uh, but the output issue will be very significant, and I really, really would like to see how this will play also in e-discovery. How this will play out, and how creators and artists will approach it, because we live in times when I think we can also be optimistic. If you want to create something with, let's say, artistic value, or something that doesn't sound as generated elevator music, my belief is, and Alyssa will perhaps agree, that you need to have some understanding of music. You need to have some human creativity. You need to have maybe professional, creative training. Um, Otherwise, the outcome maybe will still sound a bit off, and you can still use it as a tool assisting to you. You don't need a big band, right? If you are a creator, there are people working with software, uh, with AI employed already as a professional creators. But the question will be, how do you assess and technologically track the, let's say, sufficient amount of creative choices and human creativity input of my personal creative input into work, so that I can claim copyright. So that will be very exciting.
Yeah, and I think this is I think this is a really interesting thing that you touch on, and we actually have a comment here from one of our listeners saying that I think it's Crispin's writing. If the AI is superior to creators, and it is in many areas today and only improving, that makes human creators rare and thus more valuable. I really like that idea. However, and I just wanted to bring this to your attention, guys. This is one of my favorite topics to discuss. I'm definitely not an expert, but this speaks, I think, directly to the issue of whether you can discern what was created by a machine or a human. And maybe some of in our audience has heard about the Turing test. Not specifically from music, but there was back in the 50s, Alan Turing, genius scientist. He created what was called the imitation game, the Turing test, where two entities, two agents, a human and machine, are being asked questions by interrogator. Questions are usually in the text prompt format, and at some point at the end of the conversation, if the interrogator cannot really determine whether the answers belong to human and machine, the machine kind of passed the test, meaning that it displayed the human-like intelligence. So you cannot say whether the content was generated by a human or the machine. And I've heard the argument, and I really like it. I mean, I'm totally biased here, that what AI writes is not even music to begin with. because it just can't. I mean, it writes stuff, but on the output, it kind of sounds like music. But what it lacks is that kind of the process where the humans are involved in the creation of music, their interaction. There's a really interesting discussion about what jamming means when people come together and they create something. This is what AI absolutely cannot create. So therefore, maybe on the output, it can kind of pass the test, so to speak, but kind of on the process, on the directive side, it's just not capable of doing that. But again, like if you've heard some of the AI generated music, I've heard some stuff, and it kind of sounds like Interstellar soundtrack to me, like sort of like Hans Zimmer, style. I would never be able to discern whether it was human composed or machine composed. Like, no way. If I'm just listening to this, if I'm looking at sheet music, I won't be able to. If it says like John Doe, I don't know, copyright or something like that, I would not be able to say. So this is a really open question, and I hope that Crispin is right. Saying that anything that human made will be more valuable. But again, how would we determine, right? So I just wanted to throw that mind twister in there because I think this is important, and I'm hoping. And folks, I will provide a really interesting video after the talk. There is one really interesting person on YouTube. He actually explains why, in his opinion, AI can never pass the music Turing test, so to speak. It's really fascinating. So if you're into those things, and explained really well in simple terms, you don't have to be an expert. So yeah, I mean, you might explore, because I think it's a really like important thing. Again, going back to the copyrightability, right? So if we need a human author, how do we know where that human authorship resides when we're listening to like the Mozart style, I don't know, AI generated stuff?
We have 8 minutes left, and I mean, we have to talk about the Ecuador rainforest case as the song co-creator, please, because we were kind of touching upon it yesterday with Veronica during up. I had to bring this up.
Please do. That's a fascinating case.
Yes, for people kind of not aware. So there's this I wouldn't call it like a case, but the Ecuador rainforest is so this organization, they submitted an application to the Ecuador Copyright Office to register the forest as a song co-creator, because the sounds of this forest were used in creating the song. Essentially, the flapping of the bats' wings and the leaves, sound of the leaves, the water, all the bugs, kind of all the ecosystem. And pretty much a lot of I've read a lot of about it. Just people are commenting, and it's been obviously going on and on LinkedIn, at least on my feed. And yeah, I just wanted to kind of get I got your it kind of just I got the what you were thinking about it yesterday, but just wanted to hear from you today as well, because I think there's something there. Why can't it be?
You're such a romantic.
I am.
I really wish that they will include it into the Calm library, so that you can listen to it to sort of to support.
The white noise, the white
noise, and also to support the initiative. It's very interesting philosophical thought. The one thing I wrote to you yesterday was just the Naruto case, right? about the monkey taking a selfie. What just crossed my mind is, and I'm stepping on a thin ice here because I just skimmed through the discussion, so I might be misquoting, and I will try to share it in under, let's say, maybe the event comments or something. Recently, there has been at one conference discussion how to deal with the black box argument, and where comes into play the creativity of the AI system versus the person writing the prompt or using it. Well, writing the prompt, using it, etc. And there was apparently a decision that was used as an analogy about some garden architect and the role that nature itself play into the development of his idea, leaves changing colors and stuff like that. And the court said, well, you cannot really claim copyright over work which is sort of co-authored by the nature, which is force majeure, and it's unprecedented in a sense, like sorry, how to say it, you cannot foresee what it will exactly do, right? And it seemed to be similar to the rainforest, although my understanding is that they sampled it somehow together using the AI system.
Yeah, exactly. And there's this counter argument for the people who are using this. You can't really predict how when you're using generative AI, what the image is going to be. Every time you prompt the AI model, it's going to be a different image and this sort of thing. But the counter argument to that is Pollock's works, right? He never knew what was going to be created. He just splashed the paint in all sorts of ways, and there's literally, it wouldn't be the same no matter what you do, even if you use the same I don't know, pose and try to do the same trajectory, right? How about looking at that from this perspective? So I mean, obviously not today, not because our copyright law, I think needs a major overhaul, because it's been some time since it had something updated, and probably not today. But as Alyssa said, I am a romantic at heart.
Well, yeah,
And
I don't want to
I
really
wouldn't
like
mind.
exercise really harsh judgment or
Don't
opinion.
ruin this for me.
As much as an outdoorsy person I am, and I spend like all my free time in the mountains, but you know where I stand on this particular
You should be
discussion.
one with nature at this point. The amount of
No,
time you spend
absolutely,
out
but it's
there,
like, I mean, you cannot
embrace
apply
it.
legal concepts
Of course
to.
you can.
What about the copyrightability? What about the term? What about the copyright term? How would you measure it?
No, I mean, I was in terms of like whether the rainforest can be the author of the song. Of course not. I mean, it's like, I mean, I don't even know what we're talking about here, guys. It's like, it's a really beautiful idea, but it's like we're talking about legal system created by humans for humans within within our human framework. So it's not. I mean, yeah, it's kind of a it's very cute. I would say, I don't know what other word I would use, but I mean, yeah. So, yeah, and I know we have only 3 minutes left. I just wanted to show folks something that I just came up, just came across just recently. So this is the YouTube Dream Track. So I think this is kind of the we'll left all the doom and gloom aside, all the scary legal issues. I think this is one of the successful, maybe like collaborations when it comes to AI and the artist. It's still experimental kind of platform, but it's basically where you as a user, you can create a 30-second YouTube shorts using imitated voice and music style by participating artists. So you're basically saying like, oh, I want this song by, let's say, T-Pain singing about this, and the tool will actually generate that for you. So as far as I understand, it's all consensual by the artist right now, but I mean, it's still very early stages. So I mean, I don't know if I can play like the 30 seconds and it's gonna work. Let's see. I woke up in a sunshine state that's living life to me. Yeah, so this is not a real song by T-Pain, but this is totally generated by AI, and this little track as well. That's just by another artist. Baby, we've got nothing in coming, but I know that I wish you've been wanting for so long now. That's about it. So that's just another avenue, I guess, that where I guess like YouTube and Google, they actually see value in this, that may people be actually using.
No, I really enjoyed the interesting integration of something which I suppose is part of it. It looked like somebody's iPhone video or mobile video. So it seemed to be Instagram sort of directed content or social media tailored content.
I thought it was AI generated as well.
Yeah,
the
it seemed to me.
the video. It could have been runway. I mean, for all I know, at this point, everything is synthesized and AI generated. That's why the idea of a rainforest being as a co-author is very soothing for my old soul. Something alive out there.
You could build an offline, I don't know, tribe there, or some state within the state with forbidding use of generative AI and giving rights to forest.
Yes, well,
that goes into
the whole analog.
Yeah, I mean, it's also a whole discussion about Native American traditions and how they perceive nature and things like that. And they have their own jurisdictions in the United States. The tribal governments, they have their own legislation, their own law enforcement. It's a completely different world. Very interesting, but that's a whole other topic.
Yeah, but guys, that's again for another discussion. But that's where I see very interesting area for a legal discussion about, and let's say legal support about traditional knowledge and traditional culture that is perhaps not protected by copyright anymore, but still the cultures should be able, from my perspective, to somehow take part into monetization of their let's say knowledge and creations and traditional culture.
Yeah,
and that opens up a totally other can of worms that's called English language bias and English culture bias in large language models, right? That's been it's been already a fact that large portion of all the data set these models have been trained on is based on the English language predominantly. But there have been some efforts by companies such as Cohere AI. It's been very, very wonderful to see that. But yeah, overall, it's been a lot of cultures, a lot of languages, a lot of nations are underrepresented and not represented at all a lot of the time. So, but like I said, totally different topic.
Yeah.
Thank you so much for being with us today and for this discussion.
Yeah, thank you, Veronica. Thank you. We know it's very late
for inviting me.
We know it's very late for you, so we won't hold you any longer. We're out of time, and thank you everyone who was listening today and commenting. So I might add some resources after the talk on our event page on LinkedIn if you're interested in exploring this further, reading about these lawsuits, about the AI music Turing test, and some other things that we were exploring while preparing for this discussion today. So as always, let us know if you have questions. And our next talk will be, I believe, it will be on November 14th. And stay tuned. We will announce at some point. And thank you, everyone.
Thank you so much for joining us. Thank you, Veronica. Thank you.
Bye.
Thank you. Bye-bye.